The indictment doesn't specify that because the law does not so require. In my remarks, I mentioned a couple of laws, which I will highlight again now. The first is New York State election law, which makes it a crime to conspire to promote a candidacy by unlawful means. I further indicated a number of unlawful means, including more additional false statements, including statements that were planned to be made to tax authorities. I also noted the federal election law cap on contribution limits. I'm not going to go into our deliberative process on what was brought. The charges that were brought were the ones that were brought. The evidence in the law is the basis for those decisions.
Ahead of the indictment today being brought against former President Donald Trump, we had it on pretty good authority. Everybody had pretty well surmised that there were going to be multiple charges related to falsified business records. But we all learned in Crash Course Cable TV Law School that in addition to those charges, there needed to be something that made those charges into a felony. On their own terms, those things would just be misdemeanors. Those things would not likely, therefore, result in Donald Trump being indicted. If he was going to be indicted, those falsified business records would have to be linked to the attempt to commit or conceal some other crime. Today, we found out what the other crimes would be, except those crimes aren't charged today. We saw Alvin Bragg just run through them briefly in his remarks, and he was answering questions today from reporters. He said under New York State election law, it's a crime to conspire to promote a candidacy by unlawful means. He described additional false business records charges, not the ones that were charged against Trump today, but additional false business records that were allegedly carried out by the company that owns the National Enquirer. He also described federal election law caps on contributions. Again, those were not charged today, but he cited those crimes as being essentially the aggravating factor that made the charges against Trump today into felonies. How does that work if those crimes he described today were not actually themselves charged? I put this question to two of our legal experts who are here with us today, Catherine Christian and Andrew Weissman, both from veteran prosecutors who've seen this both from a federal and a state perspective. Can either of you walk us non-lawyers through this part of these charges?
You want me to take a crack?
You go ahead.
Okay. So the first thing to know is that the statute in New York that says you can bump this up to a felony requires that you have an intent to commit some other crime. You don't actually have to commit that crime. So that's why you wouldn't necessarily need to charge it, and that's something that Alvin Bragg said. Also, if one of the crimes that you're thinking can be used as that bump up is a federal crime, then that is not something that you could charge in state court anyway. Now, this really goes to Chris's question in the last segment, where he sort of said, isn't this really still a tenuous case? Isn't there a problem? Because this is really a legal issue in this case more than a factual issue. And this is where I actually was impressed in terms of what was charged here, because there's so many different ways in which the DA has laid out how he can get to a felony. He has suggested in his oral remarks that one way is the federal campaign laws. Another way is the state campaign laws. A third way is he talked about AMI issuing false statements, and this was in furtherance of those false statements. And a fourth way was tax charges, exactly what you had laid out, Rachel, in terms of the scheme to have Michael Cohen commit tax fraud. Which, by the way, is exactly the kind of thing that was alleged in the Trump Organization Weisselberg case that just resulted in convictions in November. So those give the DA a lot of room. So even if there's an attack on one or two of them, particularly the state crimes of tax fraud and the AMI false statement charge seem very solid. It seems very hard to imagine a motion to dismiss that's going to knock out all of that and reduce all of the charges to misdemeanors.
And it doesn't mean that when you describe, Andrew, the district attorney as having laid out a lot of different paths by which he can get to a felony, sometimes, like when you see that in a movie script or something, you think, oh, they've given you a whole bunch of different options because they don't have one good, strong one. But in this case, you're saying that's not a sign of weakness, that's a sign of strength. of the case, because even if one of them gets knocked out, they've still got other viable means.
Yeah, absolutely. That when I would charge, and I'm sure when Catherine charged, if you have a really weak one, you don't want to do that and have it sort of taint all of the other ones. But if you have like 4 really good options, lay them all out. The defense is entitled to make motions, and you never know what a judge is going to do. That's the reason you lay out your strongest ones. And here, there are just too many options that I'm sure when the defense looked at this, they were actually thinking this is more than we had sort of bargained for.